Welcome to SCOTUScast, a project of the Federalist Society for Law and Public Policy Studies. Our contributors join us from around the country to bring you expert commentary on U.S. Supreme Court cases as they are argued and decisions are issued. The Federalist Society takes no position on particular legal or public policy issues. All expressions of opinion are those of the speaker.
Thank you for tuning in for this episode of SCOTUScast. I'm your host, Nick Garfinkel, on behalf of the Faculty Division of the Federalist Society. On March 7th, the court decided Wooden v. United States, holding that William Dale Wooden's 10 burglary offenses arising from a single criminal episode did not occur on different occasions, and thus count as only one prior conviction under the Armed Career Criminal Act. Joining today to discuss this 9-0 decision is Vikrant P. Reddy, Senior Research Fellow at the Charles Koch Institute.
This case, Wooden versus United States, I think will enter the pantheon of cases that help us understand why people are so irritated by lawyers. Because it's one of these cases where the answer is incredibly obvious. Every single person would get the answer immediately, and in fact, the case went 9-0. But it's the reasoning that gets very complicated. And there are a lot of different opinions that battle back and forth about how exactly you get to that answer. I think the average person would say, well, who cares? We all know what the answer is. But of course, lawyers and judges can't do that. We've got to come up with really precise reasoning so that we set a precedent that we can use in the future. That was a little harder to do in this case, but we'll talk through the opinions and what was eventually decided on. So the case involves a man named Dale Wooden, who in 1997 in Dalton, Georgia, broke into a storage unit and robbed it. Then he took a hammer and he smashed through the drywall of the storage unit. He entered the storage unit next door and he robbed that one. He took the hammer again, he smashed through the drywall, he entered the third unit, he robbed that one, and he does this such that he ends up robbing 10 storage units in total. And in fact, he pleads guilty to 10 counts of burglary because he stole from all 10 of these units. Now, before we get into the law here, I just want to ask everybody on the call to think through, if 17 years went by, how you would describe that story. I feel confident that the people on this call would probably say something like, you won't believe what Dale Wooden did one crazy night. You won't believe this unbelievable thing that happened to Dale Wooden once, or that he did once. Or let me tell you about something that Dale Wooden did 17 years ago. You would keep using the language of this one time, or something happened once, or this thing happened. I do not think that anybody on the call would say something to the effect of, over the course of the last 17 years, Dale Wooden has committed 10 robberies. Now, you'd be technically correct in saying that this one night that all these things happened is a unit within a broader 17-year period. He did rob these 10 storage units. In fact, he even pleaded guilty 10 times or to 10 different counts. So it would be technically correct, but somehow that's just not the way we talk. And that's maybe even more importantly, not the way we think. We just don't process that event in that way. Now, why does that little linguistic digression matter? It matters because 17 years later, a police officer entered Dale Wooden's trailer and he found a firearm lying around. And Wooden was a felon who should not have had that firearm and was subject to penalty. But we've got a statute, the Armed Career Criminal Act, that says that if Dale Wooden is a, quote, career criminal, the penalty is greatly enhanced. And the statute says that if he has, let me get this language correct, if he has committed these offenses on occasions different from one another, and it's 3 or more times, on occasions different from one another, then he's a career criminal. And he's subject to a penalty in this particular, well, in any case, a minimum penalty of 15 years. which in this particular case would have been about 13 years longer than what the probation officer was recommending. That's an extraordinary difference, a 13-year sentence difference if he is a career criminal. Now, again, in ordinary language, we don't think of this night where he robbed all of these storage units as making him a, quote, career criminal, although they did happen in a sense on separate occasions, or at least that's the sense that was argued by the prosecutors. That was an argument that was accepted by the district court. That was an argument that was again accepted by the appellate court, the Sixth Circuit, and it went up to the Supreme Court to really take a close look at the question of what an occasion is and whether or not in this case Dale Wooten had committed robbery on 10 separate occasions or whether or not all this happened on one occasion. Justice Kagan wrote the opinion. She had two arguments. The first argument, the one that really won the day with everyone, was simply the argument that I made earlier, which is that this is not the way normal people talk. It's not even the way normal lawyers talk. This is not the way that we talk or think or process an event like this. This is quite obviously one occasion. It was something that happened once. It's not the kind of thing that would render somebody, in our minds, a, quote, career criminal. And so the 15-year penalty would be just needlessly harsh. And it was more appropriate to look at the kinds of penalties that were recommended by the probation officer. She did give a separate argument, one that was based on legislative history. There's kind of a side debate involved there because Justice Barrett, joined by Justice Thomas, criticized that line of reasoning. And these kinds of debates will be familiar to most Federalist Society audiences, especially those who are familiar with Justice Scalia's critiques of legislative history. Justice Barrett and Justice Thomas just felt that that's not really the right way to analyze a case like this. They're more comfortable with just the sense of how do ordinary people think through this. Now, on the other hand, for those who work in criminal law, things get a little bit interesting when you get into a couple of other separate opinions. The first it's worth talking about is an opinion by Justice Gorsuch that was joined by Justice Sotomayor. And it's always really interesting, on a side note, when you get one of these Gorsuch-Sotomayor concurrences or dissents, they're coming from time to time in cases that involve civil liberties. And I think they're really emerging as kind of a civil libertarian bastion on the court in a lot of ways. And they did so here also. Justice Gorsuch and Sotomayor agreed with the reasoning in Justice Kagan's opinion that this is just not the way ordinary people process things like this. On the other hand, they said, there's an easier way to go about doing this case rather than diving into the psychology of how people think and process language. You simply apply the rule of lenity. They argue that the rule of lenity is this very basic canon of construction that goes back hundreds of years. It's older than the United States itself, goes back to Blackstone at least. It's something that we probably don't apply enough. The rule of lenity is a canon of construction that says that whenever you've got an ambiguous criminal statute, you just can't quite figure it out. It could go this way, it could go that way. It's really 50-50. The tie goes not to the government, but to the person who's going up against the government. And it's just a basic rule for ultimately the protection of liberty. The idea is that if you have a rule like this, the burden is really on the government to get the drafting of statutes right, to get the statutes written in such a way that, obviously protect public safety as they must, but do their best to also ensure and protect individual liberties. And if you've got a statute that doesn't quite hit that balance, tie goes to the defendant. It's a very basic and very old canon of construction, and one that Gorsuch and Sotomayor thought we ought to use here. Now, Justice Kavanaugh actually wrote himself to take on this rule of lenity question because he pointed out that the rule of lenity is used very infrequently for fairly good reason. He said it is generally thought to be a last resort. You try all sorts of different canons of construction, all sorts of different statutory interpretation methods, and only if you've exhausted all other possibilities do you apply something like this rule of lenity, tie goes to the runner kind of rule. And he worried that as Gorsuch and Sotomayor were contemplating it, we would start applying the rule of lenity earlier in the process rather than as a last resort. There are arguments, incidentally, for doing that. There is a recent law review article by Sean Hopwood, professor of law at Georgetown, about using the rule of lenity a bit earlier in the process rather than as a last resort, which I do recommend to everybody on the call who's interested in these issues. But Kavanaugh said he wouldn't go that rule of lenity route. And he's also not necessarily sure, although he completely agrees with the ordinary language argument, he's not sure that was the best way to get to the result in this case. What he was looking for was a revival of mens rea. Everybody knows that in criminal law, you don't have a crime unless you have both the actus reus and the mens rea. The actus reus is just simply whether or not the bad event happened. But the mens rea is whether or not you have the bad mental state of mind. If you don't have the correct state of mind, then you've really just got an accident rather than a crime. There are different levels. Of course, you could do something purposefully, you could do something knowledgeably, you could do something recklessly, you could do something negligently. There are different ways to think through mens rea. It's a complicated issue. It's not necessarily open and shut, but mens rea is what makes something a crime rather than a tort. And it's a really critical part of our law that in a variety of ways is probably eroded. And Kavanaugh was trying to, really get this issue on the table, saying, you have a case here where this person clearly did not understand, did not realize, did not know, not have the mens rea, did not know that he, under certain interpretations of the law, had committed robbery on 10 different occasions and therefore was subject to this dramatically enhanced penalty. We don't really apply mens rea in that way. Our judges don't tend to, but maybe they should. And maybe that's the kind of thing we ought to be thinking about. Maybe that's the sort of revival of mens rea that would add a little bit of clarity and in some ways decency to our criminal law. So there are very interesting arguments here where Justice Kagan and the court in general is pursuing this ordinary language argument. Justice Gorsuch and Sotomayor are raising this rule of lenity argument. Justice Kavanaugh is raising this mens rea argument. There's also the side question about how you rely on legislative history for things like this, which Justice Barrett and Thomas are concerned about. And overall, the outcome of the case is quite clear. I don't think anybody would really doubt it, but it's an absolutely fascinating case to think through legal reasoning and the process of legal reasoning. It's the kind of thing that I suspect we will see in syllabi for many years to come, because it's just great for teaching law students. Before I close, though, I want to talk about what happens as you read through the opinion, which is all in all, it's 43 pages. You get to the very last word, which is Gorsuch's concurrence, and you get to a final footnote. You read this footnote and you see that Gorsuch is laying the seed for what he believes will be a very significant issue to come in the future. What Gorsuch is talking about in this final footnote is the question of acquitted conduct, which people who follow criminal law and the court very closely have probably had their eye on for many years. In this case, or maybe I should go back and say, under the Fifth and Sixth Amendments, a jury has got to find beyond a reasonable doubt all the elements that led to a defendant's ultimate sentencing. But in this case, the question of what constituted an occasion is not something that was decided by a jury. It was something that was decided by a judge during the sentencing phase. It was just trying to figure out how to define that term in the statute. But it mattered. It wasn't just some minor side issue. It was the difference between, as we talked about, 2 years or 15 years in prison. And it's another one of these cases where the judge is making decisions using a preponderance of the evidence standard during the sentencing phase that matter to the ultimate sentencing of the defendant. And it's possibly, maybe I should say then, be careful here, unconstitutional. It's certainly worth an argument. And a number of people have raised these questions because you've got all kinds of cases where people have been, really kind of the iconic way this works is people have been acquitted of some particular charge because of various procedural matters. But then when you get to the sentencing phase, you've got a judge who knows about the conduct that they were acquitted on and can nevertheless factor it into the ultimate sentence. And this question of whether or not this is constitutional is almost certainly going to come before the court. These kinds of cases get filed frequently. They haven't taken a case yet, but Gorsuch says that one of these is almost certainly coming. I've talked to other federal judges who say, yeah, this is inevitable. It's just a question of when the perfect case comes before the court that they ultimately decide to take up. So that's Wooten, and that's what's to come in the future, according to Justice Gorsuch and many other court followers.
Thank you for listening to this episode of SCOTUScast. SCOTUScast is a project of the Federalist Society, a not-for-profit educational organization of conservative and libertarian law students, law professors, and lawyers, founded upon the principles that the state exists to preserve freedom, that the separation of governmental powers is central to our Constitution, and that it is emphatically the province and duty of the judiciary to say what the law is, not what it should be. Don't forget to subscribe to our podcast series, including SCOTUScast and Practice Group podcasts, on iTunes or Google Play. For an archive of past podcasts, as well as audio and video of past Federalist Society events, please visit our website at fedsoc.org/multimedia. That's fedsoc.org/multimedia.
This has been a FedSoc audio production.